That is a hearing consideration.
Citizens and all the citizens participation.
Yes.
That's all of them. Okay, so the attorneys are present. The first thing is I need a motion to waive the parliamentary rule in this case in order to
Reconsider.
Tonight?
Mm-hmm. Need a motion and a second, ma'am?
Motion and second. May I have a motion and a second to do that?
So moved.
Second. Yeah, motion and second to waive the parliamentary rule in this case in order to reconsider
This matter.
this matter. Would you call the roll?
Yes. Yes.
Yes.
Yes.
Yes.
Now we need a motion for reconsideration.
Now we need a motion for reconsideration.
So moved.
Second.
Yeah, motion and second. Would you call the roll?
Yes. Yes.
Yes.
Yes.
Yes. Next is a discussion on the agenda item. Yes.
Mayor and Council, you have representatives here tonight. Mark Levitt is here on behalf of the city manager, and Richard Sawicka is here on behalf of the IAF Local 38118.
There's two IAFF.
Excuse me.
Yes.
Mr. Mayor, members of the commission, thank you very much. Just very briefly, you previously entertained legislative action regarding the resolution of the impasse involving the collective bargaining agreement with the IAFF, and asking you to approve a motion to reconsider that decision as to two articles. Article 20 relating to bereavement leave and Article 29 relating to educational leave. We are asking you to accept the special magistrate's ruling, which is consistent with what the union, the IAFF, had requested be done. So we are looking for a motion and approval to accept the special magistrate's ruling so that it would be consistent with what the union has previously requested in collective bargaining.
On Article 20 and Article 29.
Right, just Article 20 and 29. There are still other articles that are not before you. We're just asking for a reconsideration as to those two, to accept the special magistrate's recommendation, which was agreed to or accepted by the union at the time.
Comments, Dennis?
No, having seen what they've written, I think that's acceptable.
Yes. Bob?
Well, I just see the one line near the bottom, the city has renumbered Article 29. Is it now Article 28?
I believe that's the way the numbering had been presented when it was filed with the union after the resolution by the city council. So I just put that clarification in there.
Right, and just so we're, again, on the same page, we're talking about the educational leave and the bereavement.
That's
right?
correct.
Only. Okay.
Good. Mary?
I'm good.
George? I'm good. Anyone else?
Mr. Sawicka.
Mr. Sawicka, would you like to speak to this?
Yeah, sure would. If I may. I'm appearing on behalf of first of all, Richard Sawicka, SIWICA, 231 East Colonial Avenue in Orlando. And I appreciate you bumping this up ahead on the schedule for the convenience of Mark and me. Having said that, I just want to make clear that I'm appearing on behalf of the union for the very limited purpose of making clear the union's position that you don't have jurisdiction to address these issues. The statutory provision that govern the already held legislative body hearing, Section 447.403, created a very detailed and comprehensive procedure by which to evaluate the parties' respective positions and in the context of the entire collective bargaining agreement and the issues at impasse. And you did that. We already had that hearing about 160 days ago. And this commission claimed, at least, attempted to balance the parties' respective positions and voted on each article and resolved within the meaning of the applicable law all the impasses, all the matters that impasse. There is no provision in the Public Employee Relations Act to come back and say, what the heck, let's take another shot and do these things. Particularly when, if you look in your materials, the motivation for this is purely litigation strategy. If you look at the cover memo, it states that. The commission's resolutions 160 days ago were reduced to writing by the city, and the city actually filed an unfair labor practice charge against the union, saying that the union acted improperly by not ratifying or submitting to a ratification vote the very document that includes the provisions that you are considering to change. You're pursuing litigation against the union, which is inconsistent with what you're considering here. Just as an aside, to my knowledge, this is the first time anywhere in the state of Florida that a legislative body has reconvened to change the decision that was already made within the meaning of the Public Employee Relations Act. I think you might want to ask, and I have asked, for what legal authority there is to do this vis-a-vis the Public Employee Relations Act. I think it's problematic. Now, the union objected to some of the city council's votes and some of the issues that you considered, and pursued an unfair labor practice charge. And the unfair labor practice was found sufficient by the Public Employee Relations Commission. And it's going forward on September 21st before a hearing officer to test the legality of the city's previous hearing. And the city, in this sitting here today, doesn't have authority to go back and try to revisit the issue, particularly for purposes of litigation strategy. Nothing you do here today can cleanse the unfair labor practices that the union claims occurred, or remedy the unfair labor practices. You simply don't have jurisdiction. And that's the union's position.
Okay, I apologize for bringing this forward. Should have left it at item 42. But having said that, what is your position?
This will be much shorter than the last year.
I believe there may be a difference of an opinion here.
Yes, if I may, just for the record, it is our position you have the authority to do this. When you acted initially, you acted as a legislative body making a legislative decision. You have the right and authority as a city commission to reconsider decisions as you would with other types of cases. This is not unique. This goes to